Good afternoon and welcome to everybody. Thank you for coming. We're delighted to have with us today Professor Ekow Yankah, who is the Thomas M. Cooley Professor of Law at the University of Michigan. Ekow specialises in political and criminal theory with a particular emphasis on the justification of punishment and also, I think, the justification of criminal law in contexts of systematic bias and injustice. I should also say that it's a real pleasure for me to see Ekow again, in as much as I taught a course with him in London in the prehistory that was COVID-free. We taught a criminal theory course and we had a lot of fun. It was a real pleasure. And it is a real pleasure to see you again, to speak about deputization and white privilege violence.
So let me say first, thank you for having me. It really, obviously there are very nice moments in our work, but to be able to come back and chat. Well, to speak a little off the record, the last time we saw each other was after we were concluding our classes, and we had maybe a celebratory toast, some food off the Strand, and we said to each other, well, of course, Singapore's very far away, but we'll make sure it's not too long. We'll do this again. Little knowing that just weeks later, the world was going to come to a screeching halt. And so after way too long, it's really a delight to be back and to be back in conversation, not just exchanging emails. And congratulations on your new post. Exactly. No, congratulations. It is an honor that your colleagues had that trust in you. I'm not at all surprised. Thank you for all having me. Thank you for coming. I know what time of the semester it is. I do these on the other side of the world, and it's always a delight, but it's a contribution, and it's to take time out of your schedule, and I'm delighted. So I've been told that while people will have had a chance to wrestle with the piece, given the demands on your schedule, there'll be different amounts of time. So I'm going to give as complete a view, or as complete a bullet point, I should say, as possible, and hopefully give you something to shoot at, as the phrase goes. I will start by saying that this is really, when I say I'm really grateful for your thoughts on this, I really do mean it. This is a very early stage draft, as those of you who took a look at it will know. And frustratingly, indeed, some of the parts that are missing are the most important parts of the paper. So if that means I'm trampling on your hospitality, the flip side of that is that the work and the comments you give me here will truly be contributing to my developing these thoughts. No matter how often we say these nice things when we give papers, I've come to the conclusion that there are only two kinds of comments that are actually incorporated when a paper is far along. You can either give somebody a devastating critique, which ruins the whole paper, that they must answer, or you can point out a typo. Anything between those two things just can't be incorporated when the paper is far along in publication, because you have to finish it. So the flip side is when you present an early when you present an early stage draft, even if you're terrified, the comments really do immediately get reflected in the paper. And so for that, I'm grateful. One last personal note, which I shouldn't say, but I rely on our friendship. I have the particular nervousness of having my oldest friend in the world and my goddaughter here listening to me speak. My goddaughter has not heard me give a presentation since she was 1.5, in a stroller at the time. And because they are utterly mystified as to what I do for a living, they decided to come. As though you people weren't nerve-wracking enough, my God. So here we go. Be gentle. That's what I'm saying. I tease. Let's turn our attention. I understand, of course, that I'm indulging in asking you to engage in a paper that's focused on some very American phenomena. And indeed, at the end, I'll be interested in the extensions of this. But the American phenomenon is one that has been so visible and indeed rocketed around the world that I hope that we can share some of the conversation and some of the knowledge. As many of you know, it's become commonplace in the last few years to describe American life as having experienced a racial racial reckoning. This racial reckoning has been induced by videos that forced Americans to take the scales from their eyes, particularly white Americans, who so often had ignored or brushed away accusations of violence facing Black and brown Americans as exaggerations or myths. So the last few years have seen numerous tragedies that the country, and in particular Black America, has tried to reclaim as either martyrs or icons. These tragedies have come on with a sort of relentless drumbeat. And the drumbeat, of course, makes it important for America to recognize the way in which they're tied together by a kind of ubiquitous racism. But my worry is that by recognizing the things that tie these episodes together, we can obscure important distinctions in the way in which racism visits violence on people of color. And these distinctions, despite my natural inclinations, are not important merely for fine philosophical or conceptual sorting, the kind of thing we are all paid to do. They're important because understanding different facets of racist violence clarifies the different social and legal tools that must be deployed if we hope to mitigate them. Let me give you three prominent examples of racist violence that have become, to some extent, global sensations. Perhaps the most breathtakingly iconic has been the death of George Floyd, a video that has rocketed around the world. Some of you, or at least some of you, recognize this video of Officer Derek Chauvin kneeling on George Floyd's neck for over 9 minutes, George Floyd begging for his life while bystanders begged Chauvin to relent, and Floyd is eventually dying. One that was equally disturbing, but not videoed, and thus perhaps treated differently, was the mass shooting conducted by Dylan Roof in Charleston, South Carolina in June 2015. Dylan Roof, as some of you remember, walked into a church with a weapon. He prayed with 9 congregants of that church, including a state senator, for something like an hour, before pulling out a handgun and shooting and killing them all. He hoped his murders would begin a race war. And so in some sense, it's important to notice that Dylan Roof had a particular relationship to his actions. What are these two relationships that I mean? If you think of George Floyd's death and Derek Chauvin, obviously we think of the role in which rogue policing and racist policing has played, in particular affecting African Americans, essentially since the time of the founding. That is to say, there is no time in American history when you can read a Black intellectual and not read about the experience of state-sponsored police violence. Roof is a little bit different. Roof, I argue, represents something like vigilante violence. The most close akin would be something like the KKK. People who saw themselves as determining what moral order should be and were willing to expunge violence in order to impose it. Of course, Roof is happily distanced in history and power, but in that sense, he still remains a grandson of the KKK. Forgive me. It just occurred to me that I should put the timer on so I have some sense. Yeah, will you poke me in the ribs at 10? And then,
Yeah.
Thank you, sir. All right. Thank you, Dean.
That's my job.
Yeah. Both of these cases have rightfully left scars on our collective psyche, but neither of these capture another iconic death of a Black man in America. I speak of the death of Ahmaud Arbery. Ahmaud Arbery in February 2020 was jogging in Brunswick, Georgia. As is well known, Arbery was chased by 3 men in 2 different white trucks. The 3 men, all 3 of them were armed. They were chasing Arbery because they suspected him, with no evidence whatsoever, of being behind a string of neighborhood robberies. These robberies were unreported, and so there's really some question to what extent they existed or were kind of part of a moral panic. In any case, they chased Arbery. Arbery, not surprisingly, seeing 3 men in 2 trucks he didn't know chasing him with weapons, ran. They surrounded him, boxed him in. Arbery then fought for the shotgun. He was shot perhaps several times and staggered away and died. As one of the men, Travis McMichael, stood over Ahmaud Arbery, he uttered a racial epithet while Arbery died. Notice that Ahmaud Arbery's death cannot be described as police brutality. While it's true that 2 of his murderers had served as police officers, neither of them were officially police officers at the time. They had separated. Nor, I will argue, can Arbery's death be described as vigilante violence. His murderers did not see themselves as acting against the legal regime. Importantly, they saw themselves as enforcing the legal regime. They saw themselves as authorized to do that which they did. And so that was their legal argument when faced with this death. That is, they argued to the prosecutor that they had killed Arbery in the commission of a citizen's arrest. And strikingly, despite the fact that there was a video of this death, 2 prosecutors saw that video and concluded that they couldn't be prosecuted under Georgia's citizen's arrest laws until a 3rd prosecutor, quite frankly, after months of political pressure and finally national reporting, charged them, subsequently having them convicted of murder. It is this 3rd type of violence that sits between state and vigilante violence that I want to discuss today. Arbery's death arose from deputized white violence, violence that's aimed at racial minorities, particularly black people, by white people who, even in their private capacity, take themselves to be authorized to police black people and especially enforce the law upon them. So if less recognizable than state or vigilante violence, I want to suggest that deputization is actually a more potent danger for black Americans. First, as a matter of magnitude, an inherently widespread assumption among white Americans that they're authorized to enforce the law upon black people dwarfs the reach of any police force. Deputization is important because it is more subtle and is more ubiquitous than road policing or vigilante violence. And importantly, it can only be recognized by seeing that it is greater than the sum of its parts. There's a field of literature about the assumptions of black criminality, about racial profiling, the expansion of self-defense law and standard ground laws, citizens' arrests, and so on and so on. But the string that ties them all together is this idea that part of what it means, I make the bold claim, constitutive in a sense of American whiteness, is the power to police black people. Just as importantly, the reason deputization is potent is because it is clothed in justified force. That is, without discounting the importance of law breaking, it is often little recognized how importantly the law works simply through its application of norms. Indeed, if I may speak off script for a minute, it's really important for people to recognize how often the law has to do very little in order to get people to obey, right? Most people don't break the law even when they have the opportunity to do so. They're captured by the normative force of the law, right? The reason I don't take Andrew's things is simply, well, there are a lot of reasons. You might be faster than I am. It's also true that I simply, besides my moral norms, simply recognize law as having normative power over me. And thus it's important to recognize that one of the features of deputization is that it gives people the confidence and strength of believing that their violence is normatively blessed, that it is authoritatively granted, and thus more dangerous. So I've discussed some of the most spectacular cases of white people reading innocuous black behavior as a deadly threat, of pedestrians waving guns at people or protesters, or in America we have cases like the Sandra Bland arrest of people demanding obsequiousness from black people who strike their displeasure. But the one last feature I want to point out is that deputization is important because it is consistently and constantly happening. That is to say, it affects us even when nothing spectacular is happening. The consciousness of black Americans that a white American might at any time feel empowered to decide what you can and cannot do shapes your life even when they're doing nothing. It is part of the reason why African Americans so often move through the day or through the world with caution, alertness, or anger. Their actions are shaped and their lives are truncated by the awareness that white people around them can claim a power to police them at any time. It is, to put it really bluntly, the reason why black fathers fear letting their sons touch another person's car. It is the feature that you know that at any time others may decide for themselves that they may enforce their view of the law. So the claim here is that there's a profound and ubiquitous yet some form of white violence that is privilege, best described as deputization. Deputization is the assumed white privilege of private individuals to police black people and enforce the law, whether real or imagined. And although it's an ephemeral social power, I'll make the claim that it is an illegitimately inherited legal power, hidden and structured by American criminal law. Indeed, I would make the bolder, if somewhat uncomfortable claim that deputization is innate to whiteness in America. Now, such claims are uncomfortable. I'm not the person who makes these claims very easily, in part because they're not amenable to empirical verification. Wandering around asking white survey takers, do you feel you have a special right to police black people, is unlikely to reveal particularly informative answers. And so there's a sense here that it's a philosophical project of reconstruction, taking our legal material and the social material and making sense of it as a felt and embedded normative power throughout our history. So, with the time I have left, I'm going to try to lay out some features of deputization. I'm going to describe how it's been embedded in American criminal law through our history, shielding a kind of white violence against racial minority, not by rogue legal actors, but within the law itself. In part two, I'll quickly describe the features of deputization as a social legal phenomenon. I will throw out some examples. Many of these are well known in America. To the extent they're not as well known here, please feel free to take them up in Q&A. Part three will distinguish deputization from other forms of racist violence already noted, that is, from rogue policing or from vigilante violence. And in part four, the part where I need the most help, I will offer, I'm afraid, some not very optimistic views on what can be done about deputization. So part one, deputization in the law. It is now commonly observed, particularly in critical race theory, that American policing was birthed by slave patrols. Now, to be sure, modern professionalized policing emerged simultaneously elsewhere. And so I want to make this claim with some caution. I think if the claim is interpreted as slave patrols were a necessary feature of policing, that's clearly wrong. Andrew Peel's laws of policing were emerging in London in 1829, if they're not the same place. So policing is in some sense a creature of modernity itself. But it is true that in America, the path dependency of policing was in many important ways structured by the first systematic ways in which we learned to watch out for law breaking and enforce the law. And that America was in slave patrol. So now, what I want to argue though is that this is not a paper about that set of literature and argument, an interesting and important debate on its own. I don't want to focus on the way in which policing became an official, authorized, professionalized force, but rather the way in which the law authorized private violence. That can be a startling kind of thing to hear, because one of the things we all learn in Philosophy 101, the kind of big buried idea that part of what it means to be a state is the legitimate capture and enforcement of legal norms, right? One of the things you learn in your early classes is that state legitimacy turns on the only actor that can legitimately use violence. But of course, this is because we're, so to speak, young. None of us are 250 years old. If you had a longer view of history, this would be a mysterious view, right? That is to say, professionalized policing is relatively new on the scene. Of course, in ancient Athens, there were guardians, et cetera, et cetera. Policing as a phenomenon is not new, but a professionalized standing police force very much is. Indeed, rather than saying that the state had exclusive control over violence, for much of human history, what the state could do is channel private violence, right? So in policing in America, policing in England, in many parts of Europe, the way in which policing occurred was what we call hue and cry. That is to say, when the police were needed, a constable or a sheriff could raise the hue, and private citizens were obligated to then pick up their arms and help enforce the law, typically to capture a felon. For those of you who are interested, I'm happy to go into the historical details of this. The 1181, the Seize of the Arms with King Henry II, which codified the common law requirement that all free citizens were to keep watch and raise arms to pursue lawbreakers. Interestingly, just over a century later, the king issued an edict that required all citizens, this is one of these wonderful general edicts, all citizens are just to keep watch, right? Whatever that means. All citizens are to keep watch, and if a stranger approaches, the citizen is to raise hue and cry, arrest the stranger and take him to the sheriff. So this was the structure of policing through much of our history. And certainly at the time, policing started to be structured, in particular in the American colonies. To be sure, let me just say, I'm happy to delve deeper in the history, but to be sure, the important note I want to say is that in England, it might have been at least theoretically possible that this hue and cry was not racially inflected. That is to say, one must remember that for most of history, many people didn't travel more than 20 miles outside of where they were born, so a stranger was a kind of uncommon thing. And of course, at least formally, the English didn't have slavery. It was a kind of complicated story. The most famous story is of the Somerset case. A Jamaican slave is brought to England on a boat. He escapes the boat and he's recaptured. And the question is whether or not you can use hue and cry to capture the slave. Lord Mansfield actually dithers and tries to avoid the case because he doesn't actually want to rule on whether or not slavery is legal in England. Ultimately, months later, he produces a decision that says, whatever the truth of slavery in England is, probably not legal. No master can use force, can use the English hue and cry to recapture a slave. And so the point is there is a way in which hue and cry could be imagined as disconnected from racialized power. But this was not the case in the United States. In the United States, as it quickly became a slaveholding society, policing was imbued from the very beginning with the understandable, if disturbing, obsession with the control over black bodies. So, for example, the very first laws that enforced the American public's obligation to carry arms in Virginia required all white free persons to have munitions in case they were called to serve hue and cry, but explicitly excluded black persons from doing so. They were not part of the police force. Most obviously, for example, the American Constitution in Article 4, Section 2, Clause 3, authorized owners of slaves to recover fugitive slaves, and no person held to service or labor in one state under the laws thereof, i.e. the slaveholding states, escaping to another, shall in consequence of any law or regulation therein be discharged from such service or labor, but shall be delivered up on the claim of the party to whom such service or labor may be due. There's a complicated story about that clause in the Constitution, including the lack of a mechanical system to enforce this. So it was really a kind of obvious compromise about empowering slave states without necessarily a police force. But those are kind of the weeds of American constitutional theory, which I'm happy to pick up. But they're not central to our story here. Because, of course, in America, there was little need to refocus attention on making sure that private citizens could police black people. Particularly in the South, the legal need to police the slaves who dominated in population, or who were who were a large and ever-growing population, and the Southern fear of black slave revolts, both real and mythic, meant that the systematic control of slaves was central to keeping a society from being torn asunder. In Carolina, initially, state militias were comprised of private persons to control the slave population. When the colonies separated, South Carolina authorized the formation of local slave patrols to arrest any slave found outside their plantation. And such recognition was always and consistently fractured by race, i.e., this was not a universal civic duty for everybody to enforce the law, but rather the laws were different. White people who were arrested, who committed crimes, had to be brought to a federal judge. Black people could be brought to vice versa. Black people were brought to a federal judge because it was a more serious crime. White people could be brought to a magistrate. White people had laws that if you falsely imprisoned them, you'd be punished. That meant that before you arrested somebody, you had to have a high level of confidence that they had actually committed a crime. Whereas if you falsely arrested a black person, no such punishment attended, and so forth and so on. Most importantly, if there's any constitutional doubt, the Fugitive Slave Acts, of which some of you are familiar, erased those doubts. The Fugitive Slave Acts required or punished any white person in any other community, i.e. if a slave escaped to a non-slaveholding state, punished them with a $500 fine, as you can imagine at the time an immense amount, for harboring a slave. Indeed, the second set of Fugitive Slave Acts upped that punishment to $1,000 and added 6 months in prison and required anybody in a free state to turn in any fugitive slave, i.e. the Second Fugitive Slave Act of 1850 deputized the entire country to police black bodies if they were free. And all of this was found constitutional in the US case of Prig v. Pennsylvania. This history, as the paper explores in some depth, continued throughout America, even after the Fugitive Slave Acts were washed away after the Civil War. And so, I mean, one interesting example was the South Carolina legislature, immediately after the defeat of the war, turns to Thomas Cobb, who's not just a slaveholder, but somebody who was quite explicitly one of the grand advocates of white supremacy. And they turned to Thomas Cobb to write the citizen arrest laws of the state. You see state after state where the laws required anybody who has a plantation of over 50 men, right, they can no longer be called slaves, but over 50 men is required to have a militia guard, right? Essentially just trying to reproduce the structure of overseers and slaves by imposing the legal duty to police black people. Indeed, there's a really darkly funny episode where the South Carolina legislature simply passes essentially a deputization law forcing white people to police black people. The governor at the time understands that the federal government will be outraged by this and vetoes it. South Carolina legislature overrides this veto. They take the same laws they had against slavery. They simply cross out slaves and insert the phrase, the changed condition of society, right? It's not very difficult to read the racist intent in these laws. Now, for those of you who aren't satisfied with my engaging in some amateur legal history, right? Not my field, and who think, well, all well and good, but this is quite some time ago. My argument, of course, is that those strains of deputization continue today, and I try to follow this through a newer section which you don't have, which is deputization during Jim Crow. But let me jump ahead to examples of deputization today. So I'm a firm believer in Faulkner, the American author's observation. The past is never dead. It's not even past. Take some of the iconic killings that have wrought the American landscape today. In 2012, Trayvon Martin, a 17-year-old boy in Florida, was shot and killed by George Zimmerman. It's actually a complicated racial story in some way. George Zimmerman is half Peruvian, though he clearly and explicitly says he sees himself as white. And George Zimmerman viewed himself as a kind of neighborhood watchman, very much self-appointed. He'd called the police hundreds of times in his few years in Florida. Interestingly enough, in all the hundreds of times George Zimmerman called the police for everything from open garages to people playing their music too loud, he never once called the police on anybody white. To be quite precise, on anybody exclusively white. He once called the police on a white person when that white person was with two Hispanic friends. So it's very clear that George Zimmerman, this self-appointed neighborhood watchman, whatever he says about himself, had managed to only find in the world of suspicious people in his neighborhood, racial minorities. Zimmerman saw Trayvon Martin walking down the street. Trayvon Martin had left his father's home in the same subdivision to get Skittles and iced tea. He called the police. The police said, "We understand. There's somebody suspicious in your neighborhood. We'll take care of it." Zimmerman said, I can follow him. The police said, "Please do not do that." Zimmerman swore and said, "I'm tired of these people always getting away with it." He used language I will not use. Followed Trayvon Martin. What we can reconstruct, for those of you who are interested, what we can reconstruct is that Martin starts running. He's scared. I mean, he's a 17-year-old boy, so strange man's following. Starts running. We can reconstruct this because he's on the phone with a friend of his. 12 minutes later, he's seen again by Zimmerman. Finally, apparently, he turns and decides to fight. They get in a fight, and Zimmerman shoots and kills him. I already told you a bit of the story about Ahmaud Arbery. In America, we also have the story of Kyle Rittenhouse. Kyle Rittenhouse is, a child. There's some Black Lives Matter protests going on in Philadelphia. in Wisconsin. Zimmerman lives across the border. He takes a long gun. A long gun is not legally permitted to possess. A long gun is, you all know what a long gun is, right? It looks like an automatic weapon. It looks like a military weapon. In America, they are startlingly illegal. So he takes what looks like a military weapon, and he decides, along with a group of people who declare themselves the private militia of this town, to go and enforce safety in this protest. To be sure, the protests have been going on for days, and there have been property damage. So I don't deny that the protests have been very, very disruptive and disturbing. But it's really quite startling that this group of citizens simply decided that they would take their weapons and enforce the law. Zimmerman ends up getting in a fight with three white men, however, and he shoots and kills two of them, right? But it's a very, excuse me, I said Zimmerman, I meant Rittenhouse. It's an interesting story about how this group of men decided they were going to police Black Lives Matter protesters. Other stories have been equally stunning, even if they haven't ended in death. There's a story of Mark and Patricia McCloskey, two very wealthy St. Louis couple, who hears that there's a Black Lives protest going on. The marchers are walking by their home on public roads, right? And they take their guns, right? And she has a semi-automatic gun, it looks like. He has another long gun. And they simply stand outside pointing their weapons at these black marchers who are simply walking by. And these stories go on and on. In America, we have a whole set of them. Some of them have just become comically stupid, right? People who decide to enforce the law on an 8-year-old girl selling water and asking her for her permits, and on and on and on. Again, I'm happy to pick up example after example in the Q&A. But the point, of course, is meant to be a threat. That is, there are, for whatever reason, I argue, structured in the law, white Americans understand themselves to have the power to enforce the law through force on Black Americans, on sites of Black protests. Further, it should be noticed that this phenomenon is, as far as I can tell, unidirectional in its racial valence. That is to say, they simply are not cases of, one can argue how visible these cases would be, but we don't have case after case of, for example, Black protesters or Black people policing white people with violence, right? Indeed, in an interesting kind of example of this, one striking case was what we in America describe as the Central Park bird watching case. In this case, a Black man, Kristen Cooper, and his sister are walking through Central Park in perfect daylight. Kristen Cooper is an interesting guy. He's a bird watcher. He also turns out to be a Harvard graduate, which turns out to be really important, right? Let me go off script and be clear about this. It turns out to be important because one of the things that matter when people doubt your word is being able to marshal a kind of virtue as Black people, right? A kind of perfection as the Black victim. And the perfect Black victim is a Harvard graduate, right? And this is somebody that we might have to take seriously. He's there with his sister, and because he's a bird watcher, he is, somewhat fastidious about where the dogs are in Central Park. Dogs observe birds. So he sees this young woman, and she's in an area we call the Bramble, and she's let her dog loose. And he tells her, you have to put your dog on a leash. She can't be here. And he's videotaping this. And she becomes incensed that he would tell her what to do, despite the fact that, in fact, in this case, it's actually the law. She actually cannot be doing this. He then tells her something like, you're really going to have to do this. They become angry at each other. He says, if you don't do this, I'm trying to remember his word, but I'm going to take action. And he pulls out a doggy treat. I'm going to tempt your dog away from this. She responds by calling the police, and it's quite remarkable because it's on video. She calls the police, so I call this kind of deputization adjacent, because she's not doing it herself. But she calls the police, and suddenly out of nowhere, her voice goes from anger to perfect pitch terror. Right? She's speaking to the police. She says, "There's this Black man in front of me. He's threatening me. Please hurry. I think she said something like, he's threatening my life." Right? Of course, the most dangerous thing he said was something like, "I'm going to get your dog to go." It's very clear that when faced with a Black man demanding of her that she comply with the law, her response is to reclaim her kind of power of law over him and just refuse the idea that he could dare, as anybody ask her to follow the law. Penultimately, as I've said, we should notice that the power of deputization need not be deployed in order to be powerful. That is to say, it is importantly the ability to structure racial relations through their latent kind of power, regardless of whether or not one is doing anything with it. So the same way sociologists have spoken about the way in which women can be affected by the male gaze or white, let's start where how women can be affected by the male gaze. It's important to think of the way in which Black people are aware of this power and can be affected by its latent power. Okay. The important couple notes I want to point out here is that to the extent I can describe deputization as a phenomenon, it sits between what I would describe as road policing and vigilante violence. And here I'm going to try to describe deputization a little bit bipolar, that is the inverse. So the parts I'm working on in the new part are how to get the positive picture of deputization very, very clear. But what I think I can do well is to describe what deputization is not in order for us to see the contours of the feature. So for example, when there are uniformed police acting in ways that are unlawful, we recognize that as unauthorized, or we might say extra virus legal power, right? That is to say, outside of their strict legal power. But insofar as it is strictly legal power, there's a sense in which we know how to address it. At least we have some of the same tools. We can punish police more, we can change qualified immunity, we can change the way in which we hire and fire, et cetera, et cetera. Notice that deputization is different than that, because it is the private actors behaving with the self-proclaimed authority to impose the law. It's not as though we can simply hire or train every single citizen to behave in X, Y, and Z way. Nor is it clear that we can simply punish our way out of it. So take, for example, vigilante violence. When people are behaving in increasingly unlawful ways, we have a set of tools. Indeed, in America, too often used tools. We worry about the over-criminalization of the pathology of American criminal law. But that's in fact because there's a kind of knee-jerk reaction when we know something is wrong, that we can impose criminal prohibitions and punishments on it. But notice that deputization is resistant to that kind of undermining. Precisely the problem with deputization is that people take themselves to have the power of law. So to impose further legal punishment is in a sense to amplify the problem rather than to try to truncate it, making it very difficult to tackle. So I argue in the paper, vigilante violence, which may look, for example, like the KKK, where people know that they're behaving unlawfully, is very different than those who believe that they're authorized by the law to act. Notice, for example, the iconic image of the KKK rider in the United States with somebody wearing a hood, precisely because they understood themselves to not be authorized. Obviously, it's a complicated picture. In many parts of American history, the law quietly or not so quietly supported people who were acting, so the local sheriff turned a blind eye. There are horrific pictures of people conducting lynchings where judges and sheriffs were involved. And so I admit that these things can not just overlap, but often be chameleon. Today's vigilante can be tomorrow's deputy and vice versa, depending on how the law treats that person. But just because these things overlap doesn't mean they're indistinct. It matters whether or not the law in your society at that time authorizes and supports your action. So for example, the KKK often felt supported by local police, but donned their hoods when federal police forces were around. All right. If those two pictures tell us what deputization is not, i.e. it is not vigilante violence, somebody who knows they're breaking the law, nor is it road policing, somebody who's officially authorized to do the law, what then is deputization? My core idea begins where others have written. That is to say, the well-known fusion of race and criminality, the idea that black men are presumptively criminals, and the idea that they need to be policed. But notice that deputization picks out a kind of policing. So for example, we often use policing as a kind of colloquial normative term, right? We can police each other in social norms, right? How one should behave. We can police each other in terms of academic norms and language, et cetera, et cetera. But here I want deputization to pick up a kind of policing. Policing in this sense, when it's used globally, means something like reflecting and or arguing over conflict over what counts as justified deployment of norms, right? So when you and I police each other's writing in that sense, whether or not this was a right footnote or we should have gone, we're policing justified norms. But I want deputization to pick up more than policing. The reason I use a term of art, and I think we should be careful, there's this kind of philosophical habit of always using new terms of art. Why is it important in this case? Because deputization is not just policing writ large. Put really plainly, I want to separate this from other forms of global racism. This isn't just somebody who thinks Black people have to stay in their place as such. Deputization is the power, the felt authorization to police these norms through the use of violence. That is to say, it is policing as such. It is the felt power of a private citizen to say, you are behaving in ways that I can not just argue and debate about. It's not just a fight about our social norms. I can enforce these norms on you. I can, in the way that we talk about policing being coercive, non-voluntary, deputization is meant to pick up that feature. It is that feature, I argue, that is central to the white experience. Not that one wants to do it, but that one has the power, if they wish, to enforce these norms through violence. And so that is the kind of phenomenon I'm trying to isolate. I know I only have a few minutes left, so let me lead to my conclusion. 2 minutes, perfect. Let me lead to my conclusion. So one of the features about working in law school is that even after you write a paper that you think gets the problem right, you're meant to say something about the solution. Here, I don't have a great deal of confidence. One of the nice things about the philosophy department is I can just say a problem and walk away. If your law colleagues just want you to do something. And worse than that, I can do something by coming up with a magical statute that will solve the problem. I don't think I have such a thing on offer here, and I apologize for that. My goal here is to try to isolate whether or not deputization makes sense of a certain form of violence that's apart from the violence of general racism, and if that clarifies the problem in ways that are helpful. I want to ask questions about whether the historical image of Black criminality can be sufficiently combated to drain the idea of deputization as legitimate. So for example, in other places I've done research in felony murder, and there's been interesting research in the ways in which as you increase people's awareness of the racism of felony murder, they actually respond by punishing Black people less through felony murder, illegitimate Black people compared to white people, right? So usually they punish the Black people more, even for the same crimes when we do these audit studies. You remind them of the racist past of felony murder, they punish Black people less. Oddly enough, though, the study shows suddenly they start punishing Hispanics more, right? So there's this question of how we can drain the sense of deputization in ways that make it not simply looking for a new place to hide. But the real features that I'm interested in here, the real things that I think deputization makes clear, are the limits of criminal law more generally, i.e., that criminal law and the simple power to pass more punitive more punitive statutes simply does not address the kind of problem when people take those very statutes as new powers to govern over Black persons. Ironically, by the same token, deputization also tells us something about the limits of the new conversation in America about abolitionism, where people are focused on phrases like defund the police, and the way in which we should reduce police forces and replace them with social services in order to lessen the racist impact of policing. Because that conversation, as dominating as important as it is focused on shrinking the power of the police, it misses the way in which Black people, and other racial minorities can be dominated by private violence, even if we shrink the official police force. Indeed, it's extraordinary to see the way in which deputization is being applied in new and interesting places. So for example, the new Texas anti-abortion laws empowers any citizen to police any person, women who are seeking an abortion and anybody who seeks to help them, it places a $10,000 bounty if you do so. And the reason, of course, so many women are outraged by this is not simply the threat to themselves, right? The reason women who are 55 are outraged by this is not the sense that they will come under its auspices, but the outrage of the idea that you're the kind of person who could be policed by your fellow citizen. Thomas Nagel, in a beautiful old piece of his, has a line: as bad as it is to be a slave, it is almost as bad to be the kind of person who can be enslaved, i.e. that you can be read as a normative kind of creature who's open to this kind of treatment. And it is that, the feeling that others think they can be deputized to police you, which is outrageous. We see the same thing in new powers granted to police people who are suspected to be unlawful immigrants at the American border. There's a kind of new sense that private citizens can be allowed to take in somebody on the suspicion that they're undocumented. Lastly, I'm really happy because I don't know enough about Singapore, and I understand that so much of the Singaporean commitment and self-understanding is to its racial harmony and its ability to skirt these kind of moments. I'm really interested in if any of this has an extension in Singapore. Or, put differently, I invite us to think about the ways in which, as we think about reducing violence and crime, we don't just think about the way in which this can be done by those who are rogue actors violating the law, but rather how when we empower people, it has an overlay in our social and legal landscape that allows some people to exert power over others. With that, I'll stop. I really look forward to your questions. I really appreciate you letting me present something at such an early stage. Thank you.
Thank you.